Hi, this is Brad Aldrich from Aldrich Legal Services. Today I'm going to be talking about, within the concept of estate planning, the difference between a trust and a will. So a will is a legal document where you set out things that you would like to occur, such as appointing a guardian or a conservator for any minor children, but also it can dictate where assets with no title go. So assets with no title, in my opinion, are things like clothing, jewelry, household furnishings, books, antique collectibles, artwork, stuff like that. Things that actually have no title. They are personal property, usually in nature. So a will can dictate where those go. Now, you can have specific gifts within the will. So if you had a particular piece of jewelry you wanted to go to a child, that's the place that you would set it out. Within the will, we usually create what's called the residue, and that is everything else that's left over after specific gifts. Now, if you just had a will and no trust, then you would have to say where that residue goes, to specific individuals or perhaps to charity, etc. Now, if you use a trust in conjunction with a will, then we create what's called a pour-over provision, where we pour over that residue into the trust. Now, the trust is definitely different than a will in the sense of it is a separate legal entity that can own assets. So that means that we can fund the trust by putting assets into the trust while you're alive, but the more common method these days is to set the trust up as a beneficiary on assets with title. So that's going to be life insurance, real estate, qualified retirement accounts, your checking account, your savings account, and all of your other types of investments like stocks, bonds, mutual funds, CDs, etc. They have title. Those are the things we worry about getting stuck in probate court. So we put the trust as a beneficiary on those assets so that if you die, those assets flow into the trust. Your will pours over your personal property assets into the trust. Now everything's consolidated there, and then you appoint a successor trustee under the trust to take over the trust and do exactly what you've set out within the trust. We normally use what's called a revocable trust, so it is amendable or completely revocable as long as the person who created it is alive. The moment that person dies, it becomes irrevocable and then cannot be changed, meaning it is set in stone. Successor trustee actually has to follow to a T the language that's contained within that trust. Now, a will appoints a personal representative, we call it PR, that used to be called executor. Now, that personal representative's job is to make sure assets get where they're supposed to go. But if you're using a trust and you pour over assets into the trust, then the personal representative has a lot less to do. So if you need any help with estate planning, the lawyers at Aldrich Legal Services can certainly help.